Every contract has two or more parties. A creditor and the debtor always feature. Each party has important rights and obligations. Clearly, the first duty is on the debtor to advise the creditor of any problems he envisages with the performance of his contract and how he plans to manage the situation. The duty to mitigate damages is clear. The debtor must act in good faith towards the creditor at all times and communicate clearly and regularly. That's the best way to deal with the situation. The creditor then has two angles to consider. The legal angle depends on the type of contract one has entered into: a loan, a lease, a construction contract, a supply of goods, or even an event. In some cases, the contract will cater for the possibility of a pandemic, but hardly anyone will have ever contemplated a global situation as the one we are seeing now. The relevant clauses usually allow the parties to free themselves from the contract obligations or to postpone performance, or may even allow repricing of the value or the cost of the obligations. When the contract doesn't deal with the issue, then we fall onto the gap-filling function we find in every legal system. Usually, the law eliminates the risk of damages for the debtor for non-performance or delay, and may even provide for the termination of a contract. In situations such as these, the law tends to support the debtor as reasonably as possible in order to ensure fairness and justice. The faster the creditor looks towards a moral angle, the better for him, because that will help him in managing the risks. The moral approach requires support, understanding, and focusing on long-term relationships with those with whom he collaborates most. We all need to assume that relationships which are important to us today need to be preserved for tomorrow. Taking a hint from the way the law deals with the situation is always very good advice.